Gary DeWaal here, and this is Bridging the Week for November 16th to 20th, and today is November 23rd, 2015. Good morning. Two senior federal law enforcement regulators indicated that seeking personal accountability will be emphasized in upcoming criminal and civil actions involving alleged corporate wrongdoing. Meanwhile, the Securities and Exchange Commission issued proposed new rules aimed to enhance transparency and its oversight of automated trading systems, including so-called dark pools that include stocks listed on national security exchanges, while the Commodity Futures Trading Commission readies for release tomorrow proposed new rules dealing with automated trading systems under its jurisdiction and possibly the registration of certain proprietary traders who directly access exchanges through ATSs. Meanwhile, it appears similar SEC rules for proprietary traders may be forthcoming too. We have a lot to cover this week on the Monday before Thanksgiving in the United States, so let's get started. Deputy U.S. Attorney General Sally Quillen Yates provided further insight into the Department of Justice's new emphasis on personal liability in connection with corporate, criminal, and civil law violations. At the same time that the Office of the United States Attorneys rolled out revisions to its written guidelines to its staff regarding corporate, criminal, and civil cases. In a speech before the American Banking Association and the American Bar Association Money Laundering Enforcement Conference on November 16th, Ms. Quillen Yates noted that the U.S. Attorney's revised guidelines, quote, now emphasize the primacy in any corporate case of holding individual wrongdoers accountable and list a variety of steps that prosecutors are expected to take to maximize the opportunity to achieve that goal, end quote. Among other things, if a corporation desires credit for cooperation, quote, it must provide all non-privileged information about individual wrongdoing, end quote. Whereas previously, corporations may have received at least some credit for cooperation, even where they did not disclose all information regarding individuals, quote, providing complete information about individuals' involvement in wrongdoing is a threshold hurdle that must be crossed before we'll consider any cooperation credit, end quote, said Ms. Quillen Yates. Separately, Andrew Seresny, Director, Division of Enforcement of the Securities and Exchange Commission, said that holding individuals liable is a priority of the SEC in cases against corporations where there are alleged violations of the Foreign Corrupt Practices Act. A federal district court in New York rejected arguments from the Committee on Ways and Means of the U.S. House of Representatives and Brian Sutter, the former staff director of the committee's Health Subcommittee, that they did not have to comply with investigative subpoenas of the Securities and Exchange Commission for documents and testimony. The SEC had served subpoenas on respondents in connection with an investigation related to the possible leak of non-public information regarding unexpected Medicare payment rates determined by the U.S. Department of Health and Human Services announced on April 1st, 2013. According to the court, the SEC claimed it possessed information in emails that Mr. Sutter may have been the source of the leak. However, the respondents claimed they were excused from compliance with the SEC subpoenas because of principles of quote-unquote sovereign immunity and the speech or debate clause of the U.S. Constitution, among other reasons. Respondents said they could not be compelled to comply with the SEC's investigative subpoenas under the doctrine of sovereign immunity because the federal government and its agencies cannot be sued unless they voluntarily consent. The court rejected these arguments as well as other arguments posed by the respondents, although in the end, it did limit the scope of the SEC subpoenas. Scottrade agreed to pay $2.6 million to the Financial Industry Regulatory Authority to resolve charges brought by FINRA that from January 30th, 2011 through January 29, 2014, the firm did not retain certain records in a non-rewritable and non-reversible format known as Write One, Read Many, or WORM, required by a rule of the Securities and Exchange Commission. The records included suspicious activity reports, written supervisory procedures, tax forms, and certain customer account statements, among other documents. According to FINRA, during the relevant time, Scottrade personnel saved relevant documents in a restricted shared drive that was not WORM compliant. The firm did not have a centralized department to ensure that all departments, quote, followed a consistent document retention process fully compliant with record retention rules, end quote, said FINRA. The Securities and Exchange Commission published proposed new rules to enhance the transparency of alternative trading systems, including so-called dark pools, as well as to augment its oversight of such entities. These rules would apply to all ATSs that trade stocks that are listed on a national securities exchange. Among other things, each applicable ATS would be required to prepare and file with the SEC certain information about its broker-dealer operator and affiliates, as well as the nature of its operations, on a new Form ATS-N, as well as all subsequent amendments. Separately, the Commodity Futures Trading Commission is expected to propose tomorrow rules mandating safeguards to automated trading systems, known as Regulation AT, and requiring proprietary traders to register with the CFTC if they access CFTC-regulated markets directly and use ATSs. The SEC is also now considering new rules to require registration of proprietary trading using ATSs. Check this out in the article, SEC Chair Tells Congressional Committee Disruptive Trading Rule and Proposals Mandating Third-Party Compliance Review of Investment Advisors, coming soon on the article version of Bridging the Week on the website. And finally, Barclays Bank and its New York branch agreed to pay $150 million to the New York State Department of Financial Services to resolve charges related to a quote-unquote last look feature on its automated electronic foreign exchange program, BARX. This feature, which imposed a slight delay between customer orders and their acceptance and the execution by the firm, was intended to prevent Barclays from being taken advantage of by electronic traders who might react faster to market developments in foreign exchanges than Barclays' platform, said the Department of Financial Services. However, claimed the regulator, from 2009 to 2014, this feature was also used by Barclays to reject orders from customers that would be profitable to them and unprofitable to the firm. According to the regulator, quote, Barclays did not seek to distinguish toxic order flow from instances in which prices merely happened to move in favor of the customer and against Barclays after the customer's order was entered on the Barclays system. End of quote. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. There is no video version of Bridging the Week next week because it's the Thanksgiving weekend holiday. So until 2 weeks from now, have a great 2 weeks. Do not overeat on Thanksgiving. And, as always, ciao.